Let's bring in our legal think tank tonight. Our guest joining us in St. Petersburg, Florida, criminal defense attorney, former prosecutor Lee Perlman is with us. In Atlanta, Georgia, criminal defense attorney, former prosecutor Ashley McMahan. It never goes the other way. I never introduced prosecutor, former criminal defense attorney, by the way. Also with us in South Orange, New Jersey, one town over from my hometown of West Orange, is media law professor and legal journalist Candace Kelly. Great to have everyone aboard tonight. Let me begin. We have two ladies, so I'll go gentleman first. Lee, you get to go first. How about that? Lee, do you think this is the judge is doing the right thing here? Because the entire world and every potential juror, I'll guarantee you, saw the original video of George Floyd dying. But now these potential jurors are not going to see any more videos going forward in any evidence that is filed by the defense because the judge wants to keep it out of the public domain. Is that the right call?
I mean, I don't know if it's the. I think what the judge is doing is kind of punting here a little bit. The state is making it clear they absolutely do not want any videos released, and they're fighting very hard on that apparently. Whereas the defense wants people, as you said, they're really trying to get the information out there and let them see what's occurring outside the courthouse every day. I don't think it's going to help them as far as a defense perspective. I don't think it's going to change that original video of what occurred and the horrific act you see. So, I mean, I think the judge is essentially just saying, look, I'm gonna cut this, balls and strikes. I'm going to give the state what they're asking for to an extent. You can keep filing your motions, describe it, and we're just going to try and get to the trial as fast as we can.
Ashley, what is the status of the jury pool right now for the George Floyd case? How do you think they are right now?
I mean, I think the jury pool is pretty tainted because a picture shows 1,000 words, right? And if the defense, I mean, and I'm speaking purely from defense counsel perspective at this point, okay? If everybody in the world basically got to see the video of George Floyd's death and his arrest, I see as the defense counsel, what's good for the goose is good for the gander. You know, you should be allowed to release your own video and to show, hey, what is happening outside of a courtroom? Is this going to be a fair, jury pool that you're getting, or are they already tainted? And I think that's what the defense counsel is trying to prove. It's what I would be trying to prove if I was the defense counsel in this case. So I understand exactly why they're doing it, and I get why they're being rejected by the judge as well.
Candace, do you think this is a potential valid reason to move this case out of the jurisdiction where it happened, which is what is happening outside of the courthouse?
I understand why they're doing it. However, I think wherever you go, because this has received international attention, that is going to get the same amount of attention no matter where you go. And that's the issue here. And when we talk about these videos, I want to talk about that George Floyd video of 2019. We look at George Floyd and they want to introduce this as maybe a pattern to show how he acted. But when we look at that video, that is actually how he acted and he lived. So if you're saying that he acted that same way in 2020, in May, then that's a problem because in that particular case, he did not live. So I think it goes against the defense to really try to put that particular video into play here. It works absolutely against them, showing them what can happen when they carry out their job and nobody dies.
Let's go to that videotape. Let's go to 2019. Again, the George Floyd video we've all seen is 2020. The defense filed a motion. They attached the video. We now have it. I'm going to show it to you. This is the initial approach by police in 2019. George Floyd is in a vehicle that has been stopped. George Floyd is not driving. He's on the passenger side. And here is the body cam from the officer who approaches George Floyd 1 year before George Floyd died.
What are you doing? Can you undo your seatbelt, sir? Sir, passenger, can you undo your seatbelt? Go ahead and undo your seatbelt.
Don't shoot me, man. Please, I don't want to get shot.
I don't plan on shooting you. I'm just saying, just take your time.
I ain't never seen him.
Okay, relax. Just undo your seatbelt. Let her take care of her guy. Just keep your hands out where I can see him. Hey,
I'm just playing with him. I'm just playing.
let me.
I thought you were playing. You serious?
Keep your hands where I can see them. Okay? Put them up on the dash. Put them on the dash.
Don't shoot me, sir. Please don't shoot me.
I'm not going to shoot you. Put your hands on the dash.
Okay.
Put your hands on the dash. The last time I'm going to tell you that. It's simple.
I got you, Scotty. I got you.
He keeps moving his hands around.
Yes, sir.
He won't listen to what I have to say.
There you go right there. All right,
Put your hands on
Okay.
top of your head.
Why y'all doing
On your head.
Top of your head.
Okay, man.
Open your mouth. Spit out what you got. Spit out what you got. I'm gonna tase you. Spit it out.
I'm out.
He's eating
No,
all
you
kinds
jerk
of
away
stuff.
from me. No, that was one yellow pill.
Put your hands behind your
That was one yellow pill, boss.
Okay, now slowly come on out.
Damn, man.
Hand on
Now
your
put
head.
your
Hand on your head.
Okay, relax then.
All right, Ashley McMahan, if the jury sees this part of the 2019 video, what does it reveal? Who does it help?
I don't think it helps the defense at all. So I'm actually surprised that the defense is trying to present it. And I think it's a very prejudicial. First of all, you can talk about somebody's prior convictions, but this is extremely prejudicial to show an entire arrest video for something that happened that is completely outside of the context of this case. And second of all, it shows an officer being extraordinarily aggressive with him for seemingly no apparent reason that I can tell. So it kind of explains any actions and any defense that the defense counsel might put up in this case. I'm not sure why they want it in.
All right, let me show you another piece of video here. Lee, I want you to take a look at this. This is another body cam video on the passenger side, and you get to see a better perspective of George Floyd. And listen to the arresting officer is talking about George Floyd ingesting what he believes are drugs. Take a listen.
He won't listen to what I have to say.
There you go right there. All right,
Put your hands on
Okay.
top of your head.
Why y'all doing
On your head.
Top of your head.
Okay, man.
Open your mouth. Spit out what you got. Spit out what you got. I'm gonna tase you. Spit it out.
I'm out.
He's eating all kinds of stuff.
No, that was one yellow pill.
Put your
All right, Lee, here's the defense theory where I think they're going with all this based upon what they filed with the court is that, listen, when George Floyd is approached by police and he's in possession of drugs, he ingests all the drugs. He did it in that video in 2019. They're going to show the video from 2020. They're going to show that little piece of the video where there's some white dot on his tongue. They're going to argue to the jury that he ingested that when police approached. They're going to say that was fentanyl. They're going to say it was the fentanyl that killed him, not the knee on the neck. Do you think the jury could follow all of that and get to the conclusion that the defense wants, that a reasonable explanation for why George Floyd died was fentanyl and not the knee on the neck?
I mean, at the end of the day, my thought on that is who cares? I mean, this video that they're trying to introduce and show from years prior, it really is not, I see no relevance whatsoever. And if they're trying to say, well, there's a propensity here because he took drugs allegedly during an arrest previously and now he's taking drugs again, allegedly, and they haven't really shown that per se that he ingested it during time of arrest. I know that there's an argument, but I don't see how it's relevant to a knee on the neck and the fact that he's literally yelling out that he is suffocating, that he is choking during that time. So no, I mean, I appreciate they're going to do everything in their power, but I agree with the other panelists. I just don't see this as a strong move for the defense. And if anything, you know, in this scenario, maybe the officers are aggressive. They're a little over the top. You can argue that, right? I think the body camera from the officers on the driver's side is more telling of why it's a little overkill, but at least there's an argument that they're not in control of the situation, right? Versus in the video of Mr. Floyd's death, they have complete control the entire time, and there's never a let up. In fact, it's just keep on pressing, right? So I guess to answer your question without rambling too much, it's at the end of the day, it's not going to be a relevant argument. And you know, he yells out or screams for help that he's choking to take the knee out.
All right.
Can I just jump in and say,
Yeah, please
I want to
do.
echo what he said, 2 words. Who cares, right? Because we look at the videos, they're similar only to a point, and then they go in 2 different directions. So they're not really relevant. They don't have anything to do with each other. There was no knee on the neck when we look at that video from 2019.
And Candace, you mentioned that, and that's the exact argument, though, that the defense is making in their papers, is that the 2 arrests are completely parallel until a point when they diverge. Let me show you the video of when they say things diverge.
Have a seat.
That would be so bad, man.
Have a seat.
Let's take this one.
Have a seat. All the way in. I gotta get all the way in there. Slide on over. I know you're a big man. You're gonna have to slide in.
It's you, man.
You're gonna have to slide in. He didn't have any ID on him.
And what the defense is arguing in the papers that they filed is that at that point he basically complied, you know, and in 2020 it was a whole different situation when it was time to get into the back of the cruiser. So what does that end up meaning, Candace?
Well, when we look at the way that he got into the back of the cruiser, there wasn't anything extreme about the way that he was not getting into the car. Nothing that would I guess, provide for the police to say, hey, I'm scared of this person to a point where he needs to be killed, or that I was defending myself. There wasn't any extreme behavior to a point where, listen, there were people who were around the street and they were filming. They weren't scared. There were many people who came from different angles. They weren't scared. In fact, the police officer was sitting there kind of cavalierly with his hand in his pocket, as if he was, you know, modeling for a photo shoot. He couldn't have been that scared with his hands that, you know, had one hand in the pocket. So when we look at all of this evidence, we will look at the pictures, when we look at the moving video, it's clear that nobody felt too threatened. And that is the problem here.
All right, when we come back, we've got a live trial on Court TV. It resumes tomorrow morning at 9 a.m. We've got the latest next.
At this Zoom court hearing, a last chance for Aaron Robinson to make a deal.
Has an offer been conveyed to him?
The committee authorized me to offer Mr. Robinson 15 years Florida State Prison if he wanted to plead to the manslaughter.
If Robinson decides to take prosecutors' offer, it will mean certain prison time.
I again reiterated to Mr. Robinson that if he wanted to plead and take the 15 years, he could do so.
Robinson is accused of killing Raul Ortiz after confronting him at his home in Waimama, Florida. Investigators say Robinson was angry about the way Ortiz flirted with his girlfriend. She complained that Ortiz made inappropriate remarks while at a neighborhood Circle K convenience store. The first police reports of the incident say Robinson hit Ortiz 3 times in the face, and according to the criminal affidavit, the victim fell to the ground. The defendant grabbed the victim's head and struck it multiple times against concrete landscaping rocks. But that version of events is being disputed by the defense. In a pretrial hearing, Robinson admitted to hitting Ortiz, but says Ortiz threw the first punch. Ortiz was taken to the hospital for treatment, showing no signs of brain activity. He never regained consciousness and died a few days later.
Our proposal to Mr. Diaz was 5 years in the Florida State Prison on the charge of manslaughter.
I had discussed with Ms. Dunker that if her client was somewhere in the neighborhood of 15 or 20 years, we could certainly rediscuss it, but my understanding is he's not interested.
The consequences of not taking the offer by the state attorney's office, Robinson could face the more serious charge of first-degree felony murder. If convicted, he faces a potential sentence of life in prison without parole. The judge wants to hear it from Robinson.
And is it your position that you do not want to relay to the state any offer that includes a sentence of Florida State Prison and 15 years or above? Is that correct?
Yes, ma'am.
And there's no further negotiation that you want Ms. Dunker to engage in with the state. Is that right?
Yes, ma'am.
Any questions about that?
No, ma'am.
While the defendant could not convince prosecutors he acted in self-defense, he's hoping a jury will see it his way and acquit him of murder.
And again, gavel-to-gavel coverage right here on your front row seat to justice, beginning again tomorrow morning at 9 a.m. Julia Janae, Court TV crime and justice reporter, was in the courtroom all day and has a preview of what we can expect tomorrow.
Tuesday, these jurors are going to be returning here to the Hillsborough County Courthouse to hear the opening statements from the state and defense. We know that the prosecution plans to call about 5 witnesses for their case in chief after those opening statements are over. They've identified a couple of detectives and 2 women who are known to both parties, both the victim and the defendant in this case. One being Kim Boyette. She's an eyewitness that lived across the street from the victim. She's the one who picked the defendant out of a photo lineup on the incident date of August 11th, 2014. That led to Aaron Robinson's arrest. She will likely testify about what she could see from her vantage point of this alleged violent beating that led to Ortiz's death. The other woman who we expect to take the stand will be Danielle Reynolds. She was someone who has been romantically linked to both the father of the defendant and the victim. So a lot of information that these jurors will be taking in tomorrow as they hear from both sides, first at the beginning of the day and then those witnesses. Vinnie?
Julie Janae at the courthouse for us. Wow. In this case, you think about it, it all started at that Circle K and what was going on there, and some mixed accounts of what may or may not have been going on. You're talking about a 58-year-old man who's the victim, Raul Ortiz, allegedly maybe harassing an 18-year-old girl, maybe kind of getting close to her and perhaps looking down her shirt. You know, it's not 100% clear right now. That's what trials are for, to figure it all out. Let's bring back in the think tank. Ashley, want to ask you, if in fact evidence is established during the course of this trial that the victim in this case, 58 years old, is at the Circle K sexually harassing and looking down the shirt of an 18-year-old who is the girlfriend of the defendant here, does that at all change or impact what happened when these 2 men confronted each other?
I mean, well, first of all, it always depends on what type of jury you get and what the jury makeup is, right? And what they consider to be the most important fact. But I think at the end of the day, Vinnie, you have to look at it like this. It doesn't really matter who threw the first punch or what the fight was over. You take the victim as they come, okay? And just because, you know, somebody started it and the other person may have had an underlying condition that you don't know about, or may have hit his head on some rocks, you know, like at the end of the day, if you killed a guy, whether or not you intended to, that's what ended up happening, and a life is lost. And I think the jurors are going to take that into consideration in this case, and they're not really going to care whether or not this guy may have been leering at at Aaron's girlfriend at all. It may just be, hey, look, if you threw the first punch, that's it.
Lee, this is one of those interesting issues for me, because on the one hand, it becomes the motive for prosecutors, but the motive also sort of damages the victim to a certain extent if the jury gets this picture of a 58-year-old guy at the Circle K looking down the shirt of an 18-year-old. It doesn't make him out to be the most sympathetic of victims. And obviously, no one should die here. I'm just talking about the way that the case could play out in front of this jury.
Yeah, I don't know. I don't think it matters. I mean, is it reprehensible? Yes. Does it make him a great guy? Not necessarily. If that's what happened, I mean, there's objective video from the convenience store apparently that shows 7-8 seconds of him standing near her. Whether he looks at her shirt or not, I mean, at the end of the day, if the prosecutors do their job and it's not that hard of an argument, this isn't a complicated factual scenario, they're going to say fine, except he leaves, the victim leaves the store, defendant later goes to the victim's residence, or at least very close to it, right? And they have the interaction that results in the victim's death. So yeah, you can sit there and say he shouldn't have done that, that was bad, but he leaves, right? There's a break. It's not like this is a heat of the moment scenario either. So if the state attorney does their job, I don't think it matters at all.
Candace, this is self-defense case. Is this one of those self-defense cases where the defendant has to get up on the witness stand and testify?
Oh, yeah. And when he gets on that witness stand, he's not going to be sounding very good no matter what he says. You know why? Because in what society does he think he lives in where he can go gather up a couple of friends because of some hearsay, jump in a car, and go kill somebody at their own home? That just doesn't happen. Actually, you know what? In 1955, it did happen with Emmett Till. Kind of the similar circumstances in terms of, hey, you said this about this woman I don't like that. So let me go grab some friends, go to your house in the middle of the night and kill you. And we all know where that civil rights case ended up and what we think about it today. It's not fair. It doesn't make sense. And as was said, there was a cooling off period. He had time to think about what was going on. He had time as he was driving to his friend's house, picking each one of them up, driving there with his girlfriend following behind him, might I add, in this vigilante fashion where they're just going to take care of business on their own. What should have happened, and I know that they were 19 years old, and I think that does play into it at the time. They were young, 18 and 19 years old. But in that situation, you should know better to say, hey, this person was sexually harassed, and that's the charge. Let's just go to the police. When do you take it into your own hands to go into someone's home? This is a 50-year-old man whose teeth were down his neck when he died. So this was not something that was just light. This man was brutally beaten to a point where his teeth had to be removed from his neck, a 50-year-old man. That doesn't look good no matter what he says on the witness stand.
Lee, how is stand your ground / self-defense going to play in this courthouse? Because I know you have a lot of experience down there.
Yeah, I've just 2 years ago, I ran a stand your ground in Hillsborough County. They denied the stand your ground. I appealed that to the second DCA, and we got a great ruling where the DCA said it was in fact stand your ground. It's one of the best defense-friendly DCA opinions we've got on stand your ground in the state right now. And stand your ground's already done here, right? So they actually ran 2 stand your ground hearings. They did one prior to the 2017 statute change that shifted the burden from the defense to the state, and that happened post 2017. So the court gave him another stand your ground and by law said it doesn't rise to that level. I'm not surprised at all. I'm shocked they ran stand your ground prior to trial here. We saw that in some of the videos I watched previously where they were only at manslaughter, right? That's really all they thought they could prove. And that's a big deal. There's no firearm enhancement here, so that caps you at 15 years. But because of testimony that they gave at the stand your ground, they upped it to felony murder because then they had the burglary arguments. They also, the tampering's a big deal. We'll talk about that later, I'm sure. But I mean, that stand your ground strategically might not have been a great move because it gave the state evidence and sworn testimony they've used to enhance. So now it's not about stand your ground. That's done. They're still self-defense. That is a factual argument that the jury will make a decision on. He's going to have some major hurdles to overcome. When you download the jury instructions that have been filed on this case, I won't go into the nitty gritty right now, but at the end of the day, he had to, not necessarily be in a place where he wasn't supposed to be in the first place. And then on top of that, he has a duty to retreat or to go to a safe place, especially when it's not his home, his castle. So that's all he's got left. That's why he has to testify. He has no option, really.
All right, and it'll all begin tomorrow morning, 9 a.m. right here on CourtTV. Jury selection we actually showed today as well. All right, when we come back, we're going to take you on the docket, another case, actually from the same jurisdiction, in front of the same judge, but a much different case. On the docket tonight, a case out of Seminole Heights. And this is an area in Tampa, down in Hillsborough County, where our live trial is in the same area. But it was a story that absolutely terrorized this neighborhood. Michael Ayala has more.
In the heart of bustling Tampa is Seminole Heights. For nearly 2 months in 2017, it was home to fear and terror.
This is a city that had just lived through Irma and has now spent the last 51 days dealing with a serial killer.
These are the faces of the victims. Benjamin Mitchell, Monica Hoffa, Anthony Neboa, and Ronald Felton, all shot to death.
We had neighbors that were living in fear. We had families that were devastated.
Mitchell was the first victim, shot near a bus stop. Hoffa's body was found in a parking lot. Neboa was killed walking home, and Felton died shot in the back. The victims had no apparent connection, except they were all killed within a half mile of one another while they were walking alone. The slayings, unprovoked and random, had investigators and the community desperate to catch the killer. The break in the case came from a tip at this McDonald's restaurant. An employee here gave the manager a bag for safekeeping. Inside the bag, a loaded 9mm handgun.
That firearm was used in all 4 murders.
The gun led police to 24-year-old Howell Trey Donaldson III. Donaldson admitted he owned the gun, but denied he committed the murders.
You murdered those people. Your phone puts you right there at specific times. We know it's you. Can you please tell us why?
The question goes unanswered, and the conversation ends when Donaldson invokes his right to counsel.
I just want to, I guess, talk to my attorney.
Donaldson's parents are shaken by his arrest.
We're people of faith, and we're going to lean on our faith as we go through this ordeal.
The Donaldsons are standing by their child. They have visited him frequently, providing encouragement and support while he is behind bars awaiting trial.
You're trying to keep your strength up, you're exercising a little bit.
I'm so broken I can't. That's what I'm trying to tell you.
Donaldson has not admitted to any of the shootings, seemingly more concerned about his own well-being during a court appearance.
Some unfortunate things to happen to me, and since I've been in there, I've become ill.
Harold Schechter, an expert on serial killers, has authored several books on the subject.
So I would tend to think of him more as a rampage killer, or possibly a spree killer. You know, these kinds of personalities often are incapable of feeling any genuine remorse.
There is no set trial date as of yet for Donaldson, but when he goes to court, he will face the families of the victims who lost their loved ones, and he will face the death penalty.
It's just having faith that the right thing's going to be done and that there's going to be justice for what was done to our loved one, Monica.
So we've got 4 victims, okay, in less than 2 months, within a half mile of each other. One terrifying ordeal for this neighborhood. But now the judge has severed the cases, so we're going to have 4 separate death penalty trials. How does the jury even get the story? I mean, to me, a trial is a search for the truth, which is what justice is, and then now we're going to have to sort of parcel out and give each jury like 25% of the story? Is that really what we should be doing here? Let's bring in our think tank, Ashley McMahan. You know, there's 4 victims. It's all related. Same weapon, same neighborhood within 2 months. Same defendant charged in all of them, but we're going to have 4 separate death penalty trials now?
Well, I think the argument here is that none of the victims were related. There doesn't seem to be one general modus operandi, right? They were all random. I think there's an equal argument to be made for putting them all together, but what is more likely than not to happen in this particular trial is that the first trial that they have, depending on how that turns out, and based on the cell phone evidence, placing him at the scene of every single case, based on how the first trial turns out, they're probably going to plea negotiate out the rest of them. I doubt that we will actually get to all 4 separate trials in this case. That's just my bet on what I think is going to happen.
Candace, here's my concern. I want the jury just to get the truth, right? The truth. And we can't tell them the whole story if we've got all these separate trials. We've got to be careful and kind of dance around this and that, rather than just putting it all in front of a jury and let them figure out if this story makes sense, if the person responsible for these 4 murders is the defendant.
Right. You know, and I like what you said. You have 25% of the truth. We're piecemealing this whole thing for anybody who's involved in all of these different juries. The problem is that with this gun, there really is a broken chain because there hasn't been evidence put forth enough to say, well, this is the gun that he used in order to shoot everybody. Maybe it's the gun that was used to shoot everybody, but have we connected him? And apparently they haven't made their case. But as was spoken, I think that once we get to this first trial, that we're going to kind of build and it will probably plea out, because going through 4 death penalty trials is something that this young man is going to have a hard time surviving. His family is going to have input along the way too, to say, listen, son, we need you to do X, Y, Z. There are going to be a lot of people in his ears before he gets to that 4th trial, probably before he gets to that 2nd trial. On the other hand, too, you've got the 6th Amendment. And because the evidence hasn't presented itself, he has the right to a fair and speedy trial. He has the right to be heard, and that's why we have it in place.
Lee, I look at this and I can look at it a couple different ways. You know, I want the whole story in front of the jury, but on the other hand, now all of a sudden prosecutors have 4 opportunities to convict him and put him on Florida's death row. What is justice here? What is the best way for justice to proceed here? Is it getting the whole story in front of one jury or a piece of the story in front of 4 different juries?
I think what happened here is this is the safest way at justice is probably the best way to summarize this. The reason I'm saying that is what I think happened. I practice in front of Judge Ward regularly. I have a lot of respect for her, and I think what she's doing is protecting the appeals. I think what she's doing is saying, look, you know, in Florida, the state gets to pick which trial goes first. That they're in charge, so they can pick any of the 4 victims to put, you know, into this scenario first. And they're going to pick the strongest. It doesn't have to be temporal. They can pick whichever case is best for them. And what I think she's trying to do is protect, because again, he's said, I'm not guilty of this, protect the appellate process instead of putting all 4 on, okay? And it's a difficult scenario for the victims' families, but the state has to sit there and explain to them, look, we're going to go first, we're going to go hard, and hopefully that resolves it all. And there's not a scenario 3, 4, 5 years from now, after all the appeals are done, we're back here doing this again. You have to relive this again. So I would argue this is the safest way to justice. And it gives, as you just said, you know, 4 shots at the apple, 4 bites at the apple. But I mean, at the end of the day, I think that the judge made a call to protect the case to the best of her ability.
Ashley, here's the other part of this, right? The victims, right? You talk about, all right, you get a guilty verdict. Maybe you get him sentenced to death in one trial. Now we've got 3 other ones. Anything short of him going into a courtroom and admitting what he did is not justice for any of these victims. I mean, we can't, and you know, concurrent sentences or things like that. To me, all of that is like, well, is one victim more valuable than any other victim? And that's the other part of the equation that sometimes I think gets overlooked.
Well, it's not a question of whether or not one victim is more valuable than another, but I think, you know, Lee made an excellent point. It's a protection of the appeals process here. And anytime you have death penalty cases, you know, there are a lot more rights that kick in for the defendant if they are convicted, right? So really bifurcating this trial into, let's say, you know, 4 different trials for 4 different victims, which I honestly don't think we're going to get to 4 separate total trials, I think actually protects the victims' families in the long run, because if you had one trial and, you know, he gets convicted, it's coming down the road in an appeals case no matter what. I mean, the defense counsel would be remiss not to, you know, invoke their rights to any sort of appeal. And, you know, you've just got a lot more leeway with that than you would with a solid case against one particular crime and this particular defendant, and then get him to plea out on the rest of them. So I think Lee made an excellent point.
All right, I'll try to trust you. You know, I don't always trust the criminal defense attorneys, but I'll trust you 2 tonight because you are former prosecutors as well. All right, we're going to continue to track this one. It's on the docket for us. Depositions coming up October 7th, 2021. We spoke with the state attorney earlier tonight. Looks like there may be some legal issues regarding that severance, and the state may actually be appealing all that. So we'll keep an eye on the trial date or dates whenever they come up. When we return, time to hear from you, the 13th juror. We posted some evidence from a case out of Michigan involving a plot to kidnap the governor. Your reaction next.
And I'm telling you what, right now, man, I'm going to make this 100% clear, dude. If this goes down, okay, if this whole thing, you know, starts to happen, I'm telling you what, dude, I'm taking out as many of those as I can. Every single one, dude. Every single one. And if you guys are going to give any of these a chance, any of these gang criminal government thugs that rob people every day, if you're even going to give them a second to try to speak or tell their story, don't even with me, dude. Don't even with me. I have zero patience for immoral, coward criminals. Okay? And guess what? I'm sick of being robbed and enslaved by the state, period. I'm sick of it. And these are the guys who are actually doing it. You know? So if we're doing a recon or something and we come up on some of them, dude, you better not give them a chance. You either tell them to go right now or else they're going to die, period.
All right. That video and the post by the man you heard talking is actual evidence in a case. It's the case out of Michigan involving the alleged plot to kidnap and put on trial the governor of Michigan. Actual evidence. And that video was an alleged training video for this militia. That was them jumping out of the PT Cruiser, getting ready for the Civil War. Unbelievable. Posted it on social media today and asked you a question. How dangerous are these anti-government groups? Incredible reaction. Let's begin with our 13th juror comment of the day coming from Susan tonight. I find the whole thing very dangerous and scary, so frightened for America right now. Candace, how dangerous do you think these anti-government groups are?
Absolutely, they are very dangerous. You can never take anything too lightly, especially when people or groups have the ego big enough to post. I mean, the holiday season is coming. This is a perfect gift for prosecutors. Everything just wrapped up right there. They don't even understand, the consequences of what is going on. They just have a mission, and that's what makes it very, very dangerous. But they haven't even really thought through this. They've just been kind of side-swiped by their goal of taking down the governor. Absolutely dangerous. Cannot underestimate them.
Joey writes, this is a baby group with a bunch of fools. I'm sure there's more serious ones we need to worry about who are still out there that will not be heard from until they do damage. Ashley, here, you've got two cases. You got the federal case, the state case, about 13 defendants we're talking about here. They're also talking about a civil war. I mean, how seriously should we take any of this? Civil war fought by 13 guys in a PT Cruiser.
Look, I agree with Joey. These are a bunch of baby fools, but you have to take domestic terrorism seriously because doesn't just have to be a North versus South thing or, an East versus West. This can be small groups of they're calling themselves militias, but what they really are domestic terrorists who want complete anarchy. Who don't trust their neighbors and think, I have no doubt, will go down fighting and think that, that they are in the right all day long when they're just acting like a bunch of morons and have no idea what they're up against and don't really know what true anarchy would look like for their privileged lives. So I have no sympathy for these gentlemen or anybody else that would back them up.
Richard writes, let them roar. The government has satellite particle beam systems in place that can track any individual down in the world and burn a hole in their head. Lee, is that true?
I assume not, but I don't know. I don't have high security clearance at this point in my life. So I'm going to assume even if they could do that, there's a lot of people and there's a lot of idiots. And it's really hard to track a lot of idiots all at the same time. So I'm not going to rely on the particle beam satellite. I would really hope that, the federal government is doing their job. And right here they were, thank goodness. And it's better than a particle beam, I think.
Final comment tonight from Ned. Forming militias is a constitutional right just as much as protesting. Cry about it. Candace, we have like 20 seconds here or so. Is it a constitutional right to form a militia?
Well, you can form a group and you have the First Amendment right to form groups on your own behalf. But here we're looking at something that's a little more dangerous because you can't form a group in order to actually harm and kill someone outside of the law. So they're not falling within the guidelines that were set up for a militia as provided by the Constitution. They don't have the rights to do that. Again, they can congregate and they can talk about certain things and their rights, but this is going to the extreme. I want to know, by the way, what Richie has been watching on TV. So, what is his sci-fi channel that he's watching?
Lee Pearlman, Ashley McMahan, Candace Kelly, great to have you on the program. Thank you so much. Have a great night. Please come back soon. All right, ladies and gentlemen, Court TV back in business. Gavel to gavel coverage. Got a live trial for you. Tomorrow morning, 9 a.m., our coverage begins. Make sure you tune in. We'll bring you all the evidence, all the testimony. In the meantime, that'll do it for me, Vinnie Politan, here tonight. As always, folks, have a wonderful evening. And don't forget to hug the kids.